At 10 o'clock last night, Texas time, in just under 10 hours since the jury began their deliberations in my custody battle with my ex-wife, the jury came in with its verdict. And it was what I'd call a split verdict. They didn't say give her primary total control. They said basically have it 50-50. But again, I'm not the legal eagle. I've got part of my legal team here, Randall Wilhite, and his wife, Allison Wilhite, both great lawyers, to just give some of the basics here. And I also have a statement I wrote that I'm going to read, because the mainstream media has really been distorting what really happened here. In my view, this was a split decision and something I've been working for, 50-50 custody, since the divorce I had with my ex-wife now more than 2 years ago. So, Randy and Allison, just a brief breakdown. Was what I said there accurate?
It was accurate, Alex. You know, what we had when we first started, when we got the settlement, was 2 years ago, was joint managing conservatorship, joint custody. And Ms. Jones had the opportunity to kind of move through some steps that were outlined in that to get her to 50-50, which is where you've wanted her. You've testified about that. You said it before. She had not gotten to that yet through orders of the court, but that's where we were trying to get her to. What the jury returned a verdict with last night is the same thing that we have now at the top, and by that I mean it's still joint managing conservator. Where we have now is a situation where Judge Naranjo has the authority under Texas law to apportion periods of possession. The jury returned a verdict giving Kelly the right to establish the primary residence, but you guys live within 8 or 10 miles of each other anyway. The next step is for Judge Naranjo, who I believe really cares for these children and wants to take care of them, to allocate the time between you and Kelly.
I want to just go ahead now before we hit one other topic and let you guys make any other points you'd like to. And thanks for letting me drag you in here to the studios. I know you guys have a lot of work currently going on. To read to the public this statement that I wrote today. I want to respond to the grossly inaccurate media reports that I lost custody of my children. My ex-wife and I agreed 2 years ago at the time of our divorce to be joint managing conservators of our 3 beautiful children. My ex-wife went to trial asking for her to become the sole managing conservator of our children and limit me to supervised access. Now that's key. I'm going to come back to that in a moment. The jury resoundingly rejected her request for sole custody and left us at the same place where we began this horrible journey more than 3 years ago. The jury agreed we should remain as joint managing conservators, with the only change being who can designate the primary residence, effectively a change of 10 miles. As only the judge in this trial can decide the amount of time each parent will have with their children. That's important, and the media is missing that. I am confident that the judge will carefully consider the various schedules that have been put in place in the last 2 years and will give each of us the time that is appropriate. I have throughout this ordeal deferred to the experts and the courts to determine the kids' schedule with due regard to their own wishes. Throughout this ordeal, I have deferred to the experts and the courts to develop a plan that is best for the children's lives and wishes. I have and will continue to place my trust in the court to continue to do what is in the best interest of my wonderful children. I want to be clear. In this ruling last night, the jury took us to where I basically had wanted to be 3 years ago when my ex-wife filed for divorce. I want us to be basically 50-50. But throughout the course of the divorce, there were some crises, and my ex had to go away for some treatment in Arizona. And she just, in my view, had not gotten completely better yet and had not gone through the experts and the court's recommendations to the point of which we had hoped that she would get. You've seen all over the news and the statement of my ex that this is about parental alienation and that I somehow, in the testimony by her and others, alienated my children and turned the 3 of them against them. So I'm going to show you from the court records here over the last 3 years, since late 2013, briefly exactly what happened. My ex-wife in December of 2013 filed for divorce. Then on February 18th, 2014, I got a letter for a filing with the court of what they were planning to go for and what they were planning to give me that I was supposed to go along with. Mondays from 6 p.m. to 9 p.m. That's when she had her dance classes. Saturdays from 11 to 6 p.m. and that I could also be open to considering sometime after church on Sundays. And then it went on to say maybe I could take my son to work sometimes if he had a tutor while he was here. Okay, so she filed and was pushing to have supervised visits and to not let me have overnights with my children. So that's how it began. Then let's move on to 2014, the actual court filing here. You can see this in Hayes County, where we lived at the time outside Austin. And it says, appoint petitioner temporary sole managing conservator or an alternative appointing petitioner or respondent temporary joint managing conservators and designating petitioner as the conservator who has the exclusive right to designate the primary residence of the children, appointing a guardian ad litem to represent the best interests of the children, including making recommendations regarding conservatorships, possessions of the children, and whether or not respondents should undergo psychological or drug assessment evaluations. Petitioner requests that the guardian ad litem appointed have a PhD in psychology and expertise in the forensic child custody evaluation. I did the drug testing, the alcohol testing. I've done it all totally clean. Just did that. I just did that to prove. So I was inducted into this system in 2014, 2013, continually. Let's go to the next document here. This is 2017. There were many in between there as well. And this is her filing with Travis County, where the case has been moved, where I now live. Her pleading in the case where the jury just basically awarded her joint custody with myself last night. Let's go directly to Section B, AJ, that's Alex Jones, should be awarded a modified possession order having all such designated periods of possession and access be supervised by social workers. No crimes, no nothing, done nothing, supervised when I see my kids with no overnight visitation until such a time as the court may make further determinations. So, we're seeing all over the news that I tried to alienate my children and took them away. We heard all those testimonies in there with no documents, no evidence, no nothing. And then we're just here with the actual documents, the whole history, and it's as if it went into a black hole. And again, Randy, this is 2017. Tell folks this is my ex-wife's second amended and fourth supplement, all responses to the rule, and this has the same thing in it. What does this say, Randy?
Well, it's the same thing. It just says that what Kelly's asking the court for, which is for you to have limited periods of possession, no overnights, and supervision. It's what she's telling us that she's going to tell to the court as to what she wants as to how to restrict you.
And if we go back to my divorce decree and the trial we had there, it says in there, I want 50-50. That goes back to the divorce that was granted, what, 2015?
That's right. It was requiring Kelly, however, to move through certain steps for her to get to that point. It's something that you've wanted. It's something you've told the court before.
And again, I never tried to take the children. She had a crisis, had to go to Arizona and then California in outpatient treatment, and then she agreed with the court to do this. And I just want the whole media and everybody else to know the real and true history of what happened here. You see in all over the news that this trial was about me trying to take my kids away from my ex-wife, when it started from the beginning in 2013, she was trying to take them away from me and have supervised visits. That is an absolute fact. And then she's there then telling the court, take the kids away because he's alienated them and give them to me, but the very filing says take them away and don't let me see them without supervisors. This is the inversion of reality. Randy Allison, thanks for coming in. Obviously, this is one of the craziest cases in the last decade, and it's wild to be right at the middle of it. But the final equation, it is all about the best interest of my children. So thank you for all your great work.
My pleasure.
Really appreciate it, Randy.
Thank you.
Appreciate you, Allison. All right, that's it for this special edition news update and clarification on the court case that's being misrepresented by MSM.